the definition of a water of the United States, or WOTUS, as we call it. For purposes of what the Clean Water Act covers, this definition is obviously essential and crucial. It is used for determining a number of applications under the law, including state and tribal water quality certification programs, pollutant discharge permits, and oil spill prevention and planning programs. Importantly, this definition is used for determining who must obtain a Clean Water Act Section 404 dredge and fill permit, which is well known for being a costly and time-consuming process, and at times simply is used as a roadblock to stop projects that some don't like, never mind the merits. I think we'll hear a lot about these permits today, as they can require mitigation, getting into hundreds of thousands of dollars for everyday activities people undertake to improve their own private property. If they take an action modifying a water and later find the area in question indeed was a WOTUS, they can face staggering fines and even jail time. The WOTUS question has been debated for decades in court, and varying presidential administrations have issued regulatory definitions of WOTUS that are quite expansive and subjective, which was most definitely the case with the 2015 Obama EPA WOTUS rule. So I was heartened in 2020 when the Trump administration released the Navigable Waters Protection Rule, which finally brought some clarity and predictability to the nagging question of what a WOTUS should be. The Trump rule balanced state jurisdiction with federal responsibilities, I thought, quite well. As such, I was concerned when the Biden administration released its final version of a new WOTUS definition, notably on the Friday before New Year's Eve in the thick of the hustle and bustle of the holidays. Imagine that. This new definition once again places unnecessary burdens on the communities, farmers, businesses, and industries who rely on clean water and clarity of the law. For example, in areas like North Carolina's 7th Congressional District, which I represent, storms can be frequent. Water often lingers in areas that shouldn't be classified as wetlands. This inconsistency of the law's interpretation and the ever-changing status of the weather promises years of headaches and legal wrangling for North Carolinians and Americans across the board. Early last year, the Supreme Court announced it would hear a case on the definition of WOTUS, which highlights the enormous impacts these rulemakings have on citizens across the country. In addition to the content of the Biden administration's WOTUS rule itself, I am particularly disappointed they forced it on the public before the Supreme Court's forthcoming decision. This action irresponsibly risks taxpayer resources and everyone's time, as the Supreme Court could very well send the administration back to the drawing board on a WOTUS definition, ultimately creating even more confusion and uncertainty. It would be common sense to pause and wait to see what the Supreme Court decides before jamming this through now. It is for this reason, along with those I mentioned previously, that Chairman Graves and I are leading, along with more than 150 of my Republican colleagues, a Congressional Review Act resolution that would void this ill-advised rulemaking. We should not have to take this step, as the Biden administration did not have to take this action. However, this is the situation we find ourselves in, and I'm confident the House will pass the resolution. I'm looking forward to hearing from our panel today about how this administration's actions will impact various sectors of the economy and our constituents. I now recognize my dear friend and ranking member Napolitano for 5 minutes for an opening statement.
Thank you, my friend, Mr. Chairman, and congratulations on your new role leading the Subcommittee on Water Resources and Environment. I am excited to continue working with you to provide flood control, water quality and protection, environmental restoration, navigation for all our local communities across the country. This subcommittee was extremely successful last Congress in addressing the bipartisan needs of the nation, from enactment of our 5th consecutive and bipartisan water bill, thank you, to the first reauthorization of the Clean Water SRF since its inception, to addressing the individual needs of unique watersheds throughout the country on a bipartisan basis. This subcommittee addressed our critical water infrastructure needs while also protecting our environment for future generations, and we look forward to a 6th bipartisan water bill this Congress. Clean water was not always a partisan issue. In 1972, the House voted to enact the Clean Water Act over the veto of former President Nixon by a 10-to-1 margin. And no issue has more support among American families than the protection of our nation's water. The history of water pollution protection in this country, the law, and science require a comprehensive approach to protecting our rivers, streams, and wetlands. Yet, former President Trump's dirty water rule will return us to those days when the Great Lakes were declared dead and some rivers were literally caught fire. There should be a strong partnership between U.S. Army Corps of Engineers, the U.S. Environmental Protection Agency, and our states, where each entity plays a responsible role in ensuring a level playing field of clean water amongst upstream and downstream states. Yet our limited experience under the dirty water rule show the exact opposite. To demonstrate, I ask unanimous consent that a summary of the state legal constraints on protecting waters not covered by the Clean Water Act, prepared by the Environmental Law Institute, be made part of today's hearing record.
Without objection.
Thank you, sir. Mr. Chairman, the Clean Water Act ensures our cities, our businesses, our farmers have sufficient, safe, and sustainable supplies of water to meet quality of life needs, our economic and agriculture needs, and our day-to-day survival, especially in arid regions of the country, such as the ones that represent Southern California. The Trump dirty water rule eliminated federal protections to a minimum of 75% of streams and wetlands that have been protected by the Act since its inception. These are the very same waters and wetlands that are critical to capturing and storing rain and snow melt to ensure a long-term water supply and recharge our underground aquifers. The dirty water rule removed protections of the streams and wetlands that are a source of drinking water to 117 million Americans. We recognize there is a cost to protecting our communities, our sources of drinking water, and our environment. However, we believe this cost should be borne by those seeking to pollute our waterways or to fill our wetlands for their own personal gain, rather than transferring that cost to the average Americans or to downstream states. The Trump dirty water rule would have led to higher bills for American families and businesses, as water agencies will be forced to clean the polluted water prior to it being delivered to our taps. The dirty water rule will increase the level of pollution in our water bodies, increasing the downstream risk of flooding in our communities, polluting resources of our drinking water, and made hardworking American families pay for the mess with increased water rates. We all want certainty. For decades, the regulations established by former President Reagan and implemented by every Republican and Democrat administration since then established a framework to achieve that certainty. But we believe we can have certainty as well as clean water. We don't have to choose between them. The Trump dirty water rule chose one definition of certainty: the elimination of federal protection of our rivers, streams, and wetlands over the goals of the Clean Water Act, which seeks rightly to restore, maintain the chemical, physical, and biological integrity of the nation's waters. Now, supporters of the Trump dirty water rule are urging the Supreme Court to create even more uncertainty through a test that would result in increased litigation and decreased protection of our water bodies. I applaud the Biden administration for overturning the Trump dirty water rule and reinstating decades-old and well-understood protections of our nation's rivers, streams, and wetlands. The Biden administration recognizes that families and businesses should not be burdened with paying to clean up the water pollution of others in order to have clean water at their tap. We must protect and strengthen the Clean Water Act to preserve the health of our country, as well as our communities, our environment, and our water-dependent futures. Again, Mr. Chairman, congratulations in your role as chairman of the Subcommittee of Water Resources. I look forward to working with you. Yield back the balance of my time.
I thank the dear lady. I now recognize the chairman of the full committee, Mr. Graves, for up to 5 minutes for an opening statement.
Thank you, Mr. Chairman. I'm not going to take up much time. By the way, happy birthday.
Thank you. It's actually my brother's birthday today. Mine will come next week, but we're celebrating early.
I'm not going to take up much time. I believe that the Obama administration and then following up with the Biden administration, this is a massive overreach of regulatory abuse when it comes to the waters of the U.S. But the thing that sticks in my craw more than anything else is when people come up to me and tell me that, and I'm specifically speaking to agriculture, but this has created so much uncertainty with communities, businesses, agriculture, farmers, you name it. But I get frustrated when people come up to me and tell me, why are you so worried about this? It exempts farmers, it exempts agriculture. And I have one simple question. If that's the case, then why are so many of my farmers embroiled in litigation over the WOTUS definitions. Person after person in my district calls and say, what do I do? I'm being sued over this, or I'm being sued over that. I can't build a pond. I can't build any of my retainment structures, whatever the case may be, and it's extraordinarily frustrating. So when people tell you that this group or that group is exempt out of WOTUS, it's simply not the case. And with that, I yield back.
I now recognize the ranking member of the full committee, Mr. Larson, for 5 minutes for an opening statement.
Thank you, Mr. Chair. If the WOTUS rule was a member of Congress, I think its seniority number would be about 75. I've been at this issue since 2005. I think was the first hearing that I attended in this committee on the WOTUS rule. So it's been a while. Hopefully we can get to an end at some point. But my state itself is defined by its clean water, including the health of the Puget Sound, the hundreds of lakes that we have, thousands of miles of river and streams throughout the state. People in my state know rivers, streams, and wetlands are intrinsically connected, and the health of our waters and our water-related economy depend on a strong partnership with the federal government and a level playing field among its upstream and downstream neighbors, including tribal lands. The need for a level playing field was the reason why 50 years ago this committee passed the original Clean Water Act. In the 1970s, Congress specifically noted in the legislative history of the act that a state-by-state, go-it-alone approach was, quote, inadequate in every vital aspect, unquote, and left waters severely polluted. So recently, my state joined several others in highlighting to the Supreme Court Congress's deliberate decision in 1972 to replace an ineffective patchwork of state laws with the Clean Water Act. In doing so, Congress sought to protect the interests of downstream states that might otherwise suffer the environmental consequences and economic burdens of weak or non-existent pollution controls upstream. That was our shared bipartisan view of clean water for decades, a strong federal-state partnership to protect our waters, where the Corps and the EPA set a robust federal floor of protections, and states could choose to do more but not less. It was that view embodied in the Reagan-era regulations that, for the most part, have been adopted by every presidential administration since. It's also the view embodied in the Biden proposal that seeks to clarify Clean Water Act regulations after a federal district court tossed out the Trump administration rules. In 2006, the Supreme Court, though, complicated the Clean Water Act by issuing a decision that instituted the use of a test for determining what waters remain protected by the act, but the court did not agree on a single test. That's where I started following WOTUS issue in several marathon hearings before this committee and subcommittee, discussing many of the same issues we're discussing today. Since the Rapinos decision, every presidential administration has adopted the two tests outlined by the Supreme Court, the relatively permanent test and the significant nexus test for determining Clean Water Act protections. The Trump administration's second rulemaking attempt abandoned the significant nexus test. The result was an unfathomable loss of federal protections in place since 1972, and no evidence that states have had the desire or resources to fill in those gaps. The Trump rule defied clean water history, defied the law, and defied science on how watersheds function. Unfortunately, this rule was rejected by a federal court only 14 months after it took effect, reinstating the Reagan-era regulations and continued use of both those tests. The Biden rule recodifies the Reagan-era framework and the use of both jurisdictional tests, but also includes significant improvements and exemptions requested by stakeholders to address legitimate concerns over uncertainty and to ease compliance. The rule seeks to balance the need to protect waters and wetlands consistent with the goals of the Clean Water Act, while trying to comply with the law, the science, and various opinions of the Supreme Court. The Biden rule is not perfect, but in my opinion, it's a far better place to start for certainty, for legality, and protecting the quality of our nation's waters. Unfortunately, the recently introduced Congressional Review Act resolution to block the proposal is likely to create more uncertainty. Should this resolution become law, it has the potential to cause even more chaos and confusion. For example, if the resolution is adopted, it's unlikely to prevent the continued use of the significant nexus test, as this test is already being utilized today. However, passage of the resolution would eliminate those stakeholder-led clarifications in the Biden rule and prevent future administrations from further improving the rule unless Congress decides to intervene. Further, enactment of this resolution could block agencies from helping stakeholders comply with any new jurisdictional test that might be announced by this Supreme Court. If If that were the case, stakeholders could be left with an invalidated rulemaking and a framework for a new judicially led test, but no guidance on how to apply that test in the field. In my view, that's the exact opposite of certainty and a big mistake. So I support this administration's effort to protect water quality and provide stakeholders with some additional clarity on how to comply with the Clean Water Act. So I want to thank you for the chance to give an opening statement, thank the witnesses for joining us today, and look forward to your testimony. Thank you.
Thank you, Mr. Larson. The ranking member and I see, have a series of dueling documents to submit for the record, and so I will go first. I ask unanimous consent to enter into the record a letter from the Associated Builders and Contractors dated February 7, 2023. Without objection, so ordered. I ask unanimous consent to enter into the record a letter from the American Road and Transportation Builders Association from February 8, 2023. Without objection, so ordered. I ask unanimous consent to enter into the record a letter from the National Multifamily Housing Council and the National Apartment Association dated February 8, 2023. Without objection, so ordered. I ask unanimous consent to enter into the record a letter from the National Association of Manufacturers dated February 8, 2023. Without objection, so ordered. I ask unanimous consent to enter into the record a letter from the National Federation of Independent Businesses dated February 8, 2023. Without objection, so ordered. I ask unanimous consent to enter into the record a letter from the National Mining Association dated February 8, 2023. Without objection, so ordered. I ask unanimous consent to enter into the record a letter from the Republican Governors Association dated January 30th, 2023. Without objection, so ordered. I now recognize my friend and colleague from California.
That's a long one, Mr. Chairman. I thank you. I ask unanimous consent that the following statements be made part of today's record. It's a letter from the Clean Water for All Coalition,
Without objection.
a letter from the Trout Unlimited,
Without objection.
a letter from the American Fisheries Society.
Without objection.
That's it. Thank you.
I thank the gentlelady. As a reminder, for documents submitted into the record, we would ask that you also please email those documents to documentstni@mail.house.gov. Again, that's documentstni@mail.house.gov. I would now like to welcome our witnesses and thank them for being here today. Mr. Garrett Hawkins, President of the Missouri Farm Bureau. Ms. Alicia Huey, Chairman of the National Association of Home Builders. Mr. Mark Williams, Environmental Manager, Luck Companies, on behalf of National Stone, Sand, and Gravel Association. Ms. Susan Parker Bodine, Partner, Earth and Water Law, LLC. And Mr. Dave Owen, Professor of Law and Faculty Director of Scholarly Publications, UC College of the Law, San Francisco. Thank you all for coming. We appreciate the opportunity to hear from you today. And as you know, when the lights hit yellow, that means to wind it down. We ask that you keep your testimony as close as you can to 5 minutes. If you run over 5 minutes, I'll have to shut you down. I don't want to do that. So try to keep it within the time limit. Mr. Chairman, did you have anything you'd like to mention?
Yeah, I do want to thanks for giving me just a second to thank Garrett Hawkins for being here. Garrett's the president of Missouri Farm Bureau, and before he was elected to lead Farm Bureau in our great state, he was also the deputy director of agriculture in Missouri, and he served with Farm Bureau as the director of all national legislative programs. So he's been working with farmers and ranchers from all across Missouri, and for that matter, from across the country, when it comes to regulatory issues, including WOTUS, for almost 20 years, I believe. So I do appreciate you making the trip out here, and thanks for being here, and I look forward to hearing what you have to say.
I ask unanimous consent that the witnesses' full statements be included in the record. Without objection, so ordered. So now we'll start with Mr. Hawkins. You are recognized for 5 minutes for your testimony.
Well, thank you, Chairman Graves, for your leadership and your kind words. Chairman Rouser and Ranking Member Napolitano, thank you for the opportunity to testify today. My name is Garrett Hawkins, and I serve as president of the Missouri Farm Bureau. I'm a fifth-generation farmer, a cattleman to be specific, from Appleton City, Missouri. It's an honor to represent the American Farm Bureau Federation, and I speak on behalf of thousands of farm and ranch families, hard-working farm and ranch families that produce the food, fiber, and renewable fuel that our nation and our world depend upon. For farmers and ranchers, our livelihood depends on healthy soils and clean water. We support the Clean Water Act. However, the vagueness of where jurisdictional lines lie has created confusion for landowners. Unfortunately, we have experienced uncertainty for decades due to ever-changing rulemakings that redefine the Clean Water Act's scope. As a result, landowners, small businesses, and American families are the ones who have suffered the most. The definition of WOTUS is critically important to farmers and ranchers, which is why we have participated in numerous rulemakings, legislation, and litigation on this issue for decades. Unfortunately, our members are extremely disappointed by the Biden administration's new WOTUS rule. The new rule will greatly expand the federal government's reach over private property by allowing them to assert jurisdiction over ephemeral drainages, such as ditches, swales, and low spots on a farm field. The use of significant nexus test allows the agencies to aggregate waters together, and the reliance on the vague terms provides the agencies the latitude to reach whatever conclusion they please. It is impossible for any farmer to know if a feature on their property is a WOTUS. Considering these features as jurisdictional waters opens up the potential for regulation of activities that move dirt or apply products to the land. Everyday farm and ranch activities, such as tillage, planting, or even fence building, in or near these features could trigger the Clean Water Act's harsh civil or even criminal penalties unless a permit is obtained. As an example, in Missouri, under the pre-2015 regulatory regime, EPA sent a threatening letter to a landowner, which included severe fines and mitigation requirements because he was simply trying to save his property from eroding by placing rock along his stream bank. This is a classic case of heavy-handed punitive action against a landowner as EPA claimed jurisdiction on the small creek that ran through his property. They asserted the creek had a significant nexus to the Mississippi River via two other connecting rivers. To add insult to injury, the agencies claim the costs associated with this rule are de minimis. This conclusion can only be made by failing to consider the entire gamut of costs that landowners will incur. One must consider not only the cost of the permit, but also the expenses for experts needed to navigate the process, such as environmental consultants, attorneys, and engineers. You must also consider the cost of mitigation and project delays, which makes the process beyond the means of many. One of the most important factors in the WOTUS debate centers around a highly consequential legal case that is currently being considered before the Supreme Court, Sackett versus EPA. This case should inform the agencies of the proper scope of a WOTUS definition. Finalizing this rule injects only more uncertainty for the regulated community. American Farm Bureau, Missouri Farm Bureau, numerous other organizations, and over 200 members of Congress urge the agencies to halt this rulemaking because of this. It defies logic that the agencies would go ahead with the development of this rule, knowing that a directive from the Supreme Court will be handed down imminently. Farmers and ranchers are extremely frustrated that our concerns were not recognized in the final rule. This new rule will create more confusion for landowners and will harm important economic drivers that benefit our communities. This unnecessary regulatory red tape places a burden on farmers and ranchers while stripping the states of their regulatory role. Thank you for the opportunity to share our perspective on this important issue. And I want to stress again that we as farmers support clean water, but we also need a clear rule. I look forward to taking your questions.
I thank the gentleman, and you were right on time. Ms. Huey, 5 minutes.
Chairman Rouser and Ranking Member Napolitano and members of this committee, on behalf of more than 140,000 members of the National Association of Home Builders, I appreciate the opportunity to testify on the impacts to the home building industry on the recent rule of Waters of the U.S. My name is Alicia Huey. I am president of AGH Homes, Inc., a custom builder and developer for over 30 years near Birmingham, Alabama. I serve as chairman of the NAHB Board of Directors. I had the opportunity to participate in the agency's WOTUS outreach. I recommended they avoid cumbersome jurisdictional concepts like the significant nexus test and provide clarity and certainty to the home building industry. After seeing the rule, I know the agencies ignored my advice. It's difficult to overstate the impact of regulations on housing affordability. An NHB study found that government regulations from federal, state, and local account for up to 25% of the price of a new single-family home and over 40% of multifamily development. Further, for every $1,000 increase in a median-priced home, it will price out over 117,000 households. Creating lots and building homes requires substantial earth-moving activity. It's never been easy for builders or land developers to tell if their activities may impact a WOTUS and therefore require a federal permit. Home building activities are unique and they are regulated twice under the Clean Water Act. Permitting requirements for controlling stormwater discharges and fill are triggered when those activities impact a WOTUS. Home builders rely on a timely and consistent jurisdictional determination process to know when they need to get a permit. A clear definition of WOTUS that bases federal jurisdiction upon observable landscape features is essential for small home builders. The rule's reliance upon the significant nexus test during the JD process falls short of providing the clarity and certainty the home building industry needs. The significant nexus test requires a federal regulator to perform a case-by-case analysis on all non-navigable isolated ephemeral waters before issuing the home builder a JD. As federal authority over private property increases, so do bureaucratic delays for home builders awaiting JDs, while federal permitting requirements increase. Our members are experiencing 6 to 12-month delays in securing JDs, particularly when their water requires a significant nexus test. This is in addition to significant delays during the permit process. Living under a regulatory regime that relies on significant nexus tests and determinations from an unelected bureaucrat will make home building inefficient and costly. Home building is most often financed using loans. During the highest inflationary period in our country that our country has seen in over 40 years, we are being asked to float our finances while we wait for a decision under the significant nexus test. These delays cost real money and directly impact the cost of housing. Unfortunately, home builders need to rely on the agencies for answers or be required to pay tens of thousands of dollars to consultants to help us comply with the Clean Water Act. These consultant fees are being passed down to the home buyers and renters. Under that rule, home builders knew which waters were jurisdictional just by walking the land. The Navigable Waters Protection Rule removed the need for hiring consultants because it excluded waters that lacked relatively permanent flow and eliminated the significant nexus test. The new rule does not add new protections for our nation's water resources, but inappropriately expands the government's authority over isolated and ephemeral waters. The agency suggests the rule provides clarity, however, it produces more questions. The rule allows the agencies to illegally take the easy way out by sweeping everything under federal authority. If the agencies are interested in developing a meaningful and balanced rule, they must take a more methodical and sensible approach. The agencies are gaining more authority than the Clean Water Act gives them, and our members must comply to keep the process moving. Lastly, I want to thank Chairman Graves and Rouser for introducing the CRA to reverse the Biden WOTUS rule. Until that is enacted, I encourage Congress to direct the agencies to delay the implementation of this rule until the Supreme Court rules on Sackett versus EPA. NEH believes there should be no WOTUS before SCOTUS. Thank you for the opportunity to testify, and I look forward to answering your questions.
I thank the gentlelady. Mr. Williams?
Good morning, Chairman Rouser, Ranking Member Napolitano, and other members of the subcommittee. Thank you for inviting me to testify on behalf of the National Stone, Sand, and Gravel Association at this hearing. NSSGA is the voice of the aggregates industry. We have over 9,000 operations in nearly every congressional district, producing over 2.5 billion tons of material that is the key ingredient to build every home and infrastructure project in the U.S. My name is Mark Williams. I'm the environmental manager at Luck Companies, an aggregate producer in Virginia, North and South Carolina, and Georgia. I have over 40 years of experience in the water treatment industry. I'm a Virginia certified professional wetland delineator since the inception of that program 18 years ago. In its 100 years, Luck Company provides aggregates that allow communities across the region to grow and thrive. We support numerous voluntary initiatives that improve waters, like using aggregate materials to restore habitat for the Atlantic sturgeon in the James River, protecting the Chesapeake Bay shoreline, or creating wetlands and other critical habitats, and have even donated a former quarry to Loudoun County in Virginia for future drinking water supplies. Like all NSSGA members, we go above and beyond the many local, state, and federal regulations to protect our surrounding environments. Remember, stone, sand, and gravel are used in nearly all building projects, public work projects, roads, highways, bridges, dams, energy projects, and airports, as well as environmental purposes such as treating drinking water, stormwater, and stream restoration. Unlike other businesses, we're limited to where natural forces have deposited those materials that we use, so we must engage in careful planning to ensure that every community has access to aggregates. And because of high transportation and environmental costs, we normally are unable to move the vast amount of aggregates we use over a long distance. NSSGA members are deeply concerned that EPA's new WOTUS rule will further complicate an already lengthy and burdensome process to establish or access these resources. Today, it takes 10 or even 20 years to develop a quarry. While the new rule is being portrayed as a familiar regulation, it in fact poses more questions than it answers by making it difficult for businesses to plan and hire the workforce necessary to supply those materials. This rule could add millions in costs and delays for supplying new aggregates. We want to do things the right way, but this unclear rule makes it nearly impossible to know what that right way is. For example, the new rule states ditches are exempt. However, the rule also states that ditches should be included if they move water from one wet area to another jurisdictional region. Seems to me the purpose of a ditch is to remove water and convey it to another location, and so the new rule would in fact make all ditches jurisdictional. Further, the rule comes at a time when our industry is working in overdrive to supply materials needed to build the projects that were authorized by this committee under the Infrastructure Investment and Job Acts. The delays and additional costs caused by multiple rules and consultations, surveys, reports, permits process could lead to the abandonment of aggregates projects. This not only impacts our infrastructure future, that hampers supply chains, it'll severely harm the ability to produce renewable energy sources. The finalization of this rule is occurring mere months before the Supreme Court is expected to issue a ruling that will likely change how the definition of WOTUS is determined, once again, requiring the agencies to rewrite the rules. We thank the bipartisan members of this Congress who have implored the agencies to wait for the SCOTUS ruling to be finalized so aggregates operators are not forced to comprehend another rule change. In closing, we thank the members of this committee for their time today to hear how the new WOTUS rule will impact the aggregates industry and our nation. We share the goals of every member of this committee to find ways to advance infrastructure investments and building projects that improve our communities and deliver economic success for every American. Unfortunately, with my decades of experience, I feel this rule falls short of that goal at a time when we are seeking to maximize the outcomes of the infrastructure investments provided by Congress. Thank you. I look forward to answering your questions.
Thank you, sir. Ms. Bodine.
Thank you, Chairman Rouser, Ranking Member Napolitano, and members of the subcommittee. Thank you for inviting me to testify today on the Biden administration's new Waters of the United States rulemaking, the WOTUS rule. I'm currently a partner with the firm Earth and Water Law. I've worked on Clean Water Act issues for my entire career, including while serving as a staff director of this subcommittee a long time ago, and as chief counsel for the Senate Environment and Public Works Committee. So my goal today is to help the subcommittee understand the scope and impacts of this new rule. No one disputes the ecological value of wetlands or the importance of water, whether the wetland abuts a navigable water or is isolated, and whether the water is in a river, if it's rainfall, snowmelt, groundwater. But just because wetlands and water supplies are important does not mean that Congress gave EPA and the Corps of Engineers authority to regulate all water in the nation under the Clean Water Act. As a former congressional staffer, I deeply respect the role of Congress in deciding where and when to grant federal authority. As described in my written statement, in my view, the rule sets up a framework that would allow EPA and the Corps to expand their authority beyond that which was given to them by Congress. In particular, the rule allows the agencies to claim extremely broad authority over isolated ponds and wetlands that they have not attempted to regulate since the 2001 Swank decision. The actual impacts are difficult to quantify because the rule relies on case-by-case determinations. However, past experience, including examples of overreach in my written testimony, suggests that the agencies will aggressively claim authority over both land and water. When landowners, farmers, and municipalities later challenge that overreach, the agencies will tell the court that they get deference because they're interpreting their own regulation. It is clear that the rule was designed to evade judicial review because most of the detail on how it's implemented is in the preamble and in these very lengthy, dense technical background documents. However, the new significant nexus test is in rule language and can be challenged on its face. The regulation says that EPA and the Corps can claim control over any tributary, adjacent wetland, or other lake, pond, stream, or wetland if they determine that it can significantly affect a navigable or interstate water or territorial sea, including by providing, quote, habitat and food resources for aquatic species located in one of those waters. The preamble uses connections between migrating salmon and the upper reaches of a tributary as an example of where this would apply. That's very disingenuous. If you look at the technical background document, you can see what the Corps and EPA really mean is that they can claim federal control over water and wetlands because an animal can carry insects or algae on feathers and fur or in their intestines and travel between an isolated water and a navigable water. Agencies call this dispersal, and what they're really referring to is bird droppings and animal scat. I cannot see how the Supreme Court would ever uphold that as a test for establishing federal control over land and water. It clearly falls within the admonition that Justice Breyer recently gave in the Maui case, which was a point source case, not a WOTUS case. But he said that the agencies should not be regulating, quote, in surprising, even bizarre circumstances, such as for pollutants carried to navigable waters on a bird's feathers, close quote. However, that's not the only example of surprising attempts to expand federal authority in the rule. As described in my written statement, the rule embraces the concepts that erosional features created by runoff can be considered regulated tributaries. Groundwater aquifers can create connections that would support jurisdiction over isolated waters. Flows from back-to-back rainstorm can be considered relatively permanent water, and water and wetlands can be called adjacent if they overlay a karst geological formation. These interpretations will have enormous economic consequences for farmers, landowners, and municipalities, but the Biden administration rule does not even include many of the exclusions that were found in the 2015 WOTUS rule that included similar expansions of federal authority. I'd be happy to answer any questions.
Thank the gentleman. Mr. Owen, you are now recognized. I don't think your mic is on. And if you can pull that microphone closer to you as well.
Yes, I will do that.
There you go.
Thank you. Okay. Thank you, Chairman Rouser, Ranking Member Napolitano, and Ranking Member Larson for the opportunity to speak with you today. In my testimony, I'm going to explain how the 2022 Waters of the United States rule is better for water quality, better for the economy, better for states, and a better interpretation of statutory text. Protecting water quality is the point of the Clean Water Act. Through years of research, scientists have concluded that we cannot have water quality in our rivers, lakes, and seas if we do not protect the smaller streams and wetlands that feed those rivers, lakes, and seas. Those small streams and wetlands are as important to larger waterways as our capillaries are to our pulmonary system, or as a tree's leaves and roots are to its trunk. Despite that importance, the 2020 rule would have eliminated Clean Water Act protection for most of the nation's small wetlands and streams. The 2020 rule never tried to explain how this change would be better for water quality, nor could it. The 2022 rule restores those protections, and it does so by establishing familiar standards that date back to 1975 and have been elaborated in detail since 1986. This will improve water quality across the nation. Next, economics. Because the new rule makes environmental sense, it also makes economic sense. Water quality is valuable. Hunting, fishing, and often tourism require clean water. Clean water is an important input for many manufacturing processes. Everyone needs clean water to drink. But drinking water treatment is expensive, and it is more expensive if the source water is dirtier. An honest appraisal of the economic benefits of cleaner water should have been part of the 2020 rule. It was not. Instead, the previous rule's economic analysis pretended that some well-known benefits did not exist, claimed inaccurately that others could not be measured, and premised its analysis on some demonstrably fallacious assumptions, like, for example, an assumption that states would simply backfill whatever protections the federal government withdrew. The whole rule was based on sleight-of-hand accounting, with that accounting designed to hide millions of dollars in costs to the American public. The new rule fixes these problems. Through a good faith accounting, it explains that restored benefits will produce hundreds of millions of dollars in benefits. Adopting this rule was the economically responsible thing to do. The new rule also supports states. This might be a sort of surprising claim because the Clean Water Act's detractors typically claim to be on the side of state power, but that claim misunderstands how Clean Water Act federalism actually works. The Clean Water Act was designed to address major problems that states could not address on their own. States have no authority over pollution sources beyond their borders, and polluting industries will play states against each other, creating a race to the bottom and seeking the weakest possible form of regulation. Sorry, I'm missing a couple pages here. I'll skip that. And, excuse me, sorry. In fact, however, the Clean Water Act was designed to respond to these state challenges by empowering states in multiple ways. So the first key way in which it empowers states is, again, by allowing them to participate in every program that is part of the statute. In addition, it allows states to comment on permits from upstream sources, and it finally allows, through Section 401, the states to assert power over the federal government. In other words, Section 401 gives states the ability to condition permits issued by the federal government in ways that are protective of state water quality. That is a huge benefit that would be taken away if the scope of Clean Water Act jurisdiction shrinks. Finally, the rule does a better job with statutory text. The key text that we are interpreting here is the waters of the United States. Under any plausible reading of that text, it would include aquatic features that have water and that are permanently present. That includes streams, that includes wetlands, that includes ponds, even if they don't have a permanent connection to some larger water body. The new rule respects that text, and in contrast, the previous rule mangled statutory text by creating some strange distinctions between waters that are covered and waters that are not. So in summary, the new rule is a better interpretation of statutory text. It is better for the economy. It is better for states. And most importantly, it is better for water quality. And I look forward to your questions. Thank you.
I thank the gentleman, and thank all the witnesses again for their great testimony. We'll now move into member questions, and I'll recognize myself for 5 minutes. Ms. Bodine, I noted in your testimony, you state that back-to-back rainstorms can be considered, quote, relatively permanent water. What would that mean for California after its recent storms, or for my home state of North Carolina after a hurricane?
Thank you, Chairman Rouser. Yeah, I was very surprised when I read that in the preamble. What's clear is that the agencies are trying to expand the relatively permanent test because they're worried that the Sackett case will in fact get rid of the significant nexus test. And so it has language in there about what would be considered relatively permanent, and remember, that would be automatically regulated, and included flows from back-to-back rainstorms as an example. That would mean that water that covered the landscape because of multiple rainstorms and then ended up moving across the landscape could be considered a relatively permanent flow. I think that's ludicrous. But the fact that they put that as an example in there was deeply troubling.
Mr. Hawkins, can you speak to how overregulation and broad scope interpretations like significant nexus gives firepower, to radical environmentalists and trial lawyers in particular, and how it creates an easy path to stall or shut down family farms and animal agriculture in North Carolina, Missouri, and across the country?
Thank you for the question, Mr. Chairman. I would say if I could use one word to describe how my fellow farmers and ranchers feel, it's overwhelmed. We feel like this new rule essentially shifts the burden of proof back to us rather than the agencies. It's almost the notion that we're guilty until proven innocent. And while folks talk about the exemptions that agriculture has had, the reality is I wouldn't be testifying today if those long-standing exemptions were tight enough that we weren't having farmers embroiled in litigation, not just in Missouri, but all around the country. So as you look at an expansive definition of WOTUS and the potential for more features to fall under federal regulatory control, our farmers have to be concerned about the citizen suit provisions and what that could mean in challenging normal everyday practices. They have every right to be concerned about future investment in their farming operations and have to second guess whether putting in place that conservation practice or building that structure or investing in that building is worth it if you're going to be embroiled in red tape and a potentially years-long process. So overwhelmed with the uncertainty that comes with an expansive rule, Mr. Chairman. That would summarize how our farmers feel.
Ms. Huey, everybody wants affordable housing. You hear that talked about all over. I certainly hear it back home. Why can't we have more affordable housing when prices are skyrocketing left and right? How would this affect affordable housing?
Thank you for the question. We talked about the 6 to 12 month delay in the jurisdictional determination. That is where our project just sits, and we continue to make interest payments. As a small business owner, that's how I make a living, is building homes. I can't absorb all those regulatory costs. I have to pass that on to the home buyer. As I said earlier, for every $1,000 increase in a median-priced home, and that's about $412,000, that's 117,000 families that it prices out of the market. And right now, about 87.5 million people cannot afford a median-priced home. Thank you.
Mr. Williams, in your testimony, you indicated that ditches can be regulated in practice under the new WOTUS rule, but the agencies say they will be exempt. What do you think is leading to this confusion?
We've had many different rules over the years. Sometimes ditches are exempt, sometimes they're included. The current rule states that any ditch that has flowing water or conveys water from one area to another becomes jurisdictional. This has a big effect on properties that have agricultural fields, for example, or even residential areas where ditches are currently included, and it affects our ability to permit areas like that. It causes lengthy delays, and we will continue to look for ways in which we can get those permits and reduce our mitigation costs for those.
I thank the panelists. My time has expired. I now recognize my good friend from California, Ms. Napolitano.
Thank you, Mr. Chairman. I ask unanimous consent to insert in the record public comments by Metropolitan Water District of Southern California and public comments from different attorney generals, especially California Attorney General and various other attorney generals supporting the Clean Biden Water Rule Act.
Without objection.
I also ask unanimous consent to include into the record the latest map produced by EPA that shows the areas of the country that depend on ephemeral and intermittent streams for the drinking water.
Without objection.
As shown above, you can tell where all the drought is, where the ephemeral and intermittent streams meet, which are affected most. Mr. Owen, many California residents and farmers receive water that starts ephemeral or intermittent streams. Over the past month, the West has experienced extensive storms that have temporarily replenished the streams, but are unlikely to resolve the long-term drought. As Southern California MWD and what California's Attorney General have stated in the comments just submitted for the record, source water must be protected by the Clean Water Act, or else families, businesses, and farmers will bear the cost of cleaning the water before it is suitable for drinking, swimmable, or usable. Can you discuss how important it is for water agencies and water users to have protection of their water sources and what impacts they face if their waters are not protected?
Yes, there are two main effects that come from failing to protect source waters. One is a loss of water supply. If you fill in source waters, then often you are filling in areas where water infiltrates into the ground and then back into surface waterways, or from which it flows into larger waterways. That water instead moves off the landscape much more quickly as a flood, which is obviously damaging, but it also means that later on, when things dry out and we need more water, it's not there. And so that forces water suppliers to go and search for additional water, which can be very costly if they can find it. The other effect is a loss of water quality. That's because pollution flows downstream. And so as we put pollutants in source waters, which is what we are discussing doing today, some of that pollution will migrate downstream. We also lose the pollution control ability of source waters. So smaller waterways are very, very effective at taking some nutrients out of waterways. When those nutrients move downstream, we tend to get blue-green algae blooms, which are toxic, which can again shut down water supplies. So all of this means that when we don't protect source waters, we are essentially giving up a significant part of our water supply and water treatment infrastructure. And then we just have to spend more money further downstream in order to replace the infrastructure we've let go, and those costs are passed on to consumers.
Thank you, sir. Mr. Owen, during the Trump administration, efforts were made to roll back the protections under the Section 401 of the Clean Water Act, which allows states and tribes to protect state water resources. Can you discuss the importance of strong Section 401 protections and how it might be impacted by the Trump Dirty Water Rule?
Yeah, so I think Section 401 is one of the least appreciated and most important parts of the statute. As I explained earlier, Section 401 is key to the Clean Water Act, giving states power to protect their water quality and power over the federal government. And during the Trump administration, the administration proposed rules that were specifically designed to gut Section 401 authority and limit state power. I think that gives the lie to the claim that this is all about protecting states or that it is significantly about protecting states. That was not the motivation. If you combine a loss of authority under Section 401 with a loss of the scope of jurisdiction under the Clean Water Act more generally, that's a 1-2 gut punch to state power to protect water quality, because it means not only do the states have less influence where jurisdiction exists, but they also have less ability to protect themselves from activities authorized by the federal government.
Mr. Webster, you're recognized for 5 minutes.
Thank you, Mr. Chair. Mr. Hawkins, you, I think, mentioned in your testimony that there were advantages, and one of those advantages was low-lying areas in a field would collect water. And could you explain how those are advantages?
Can you repeat the last part of your question?
Could you explain how having low-lying areas in a field that collect water in a storm or something are actually, I think you used the word advantage. So how are they advantaged by that?
Well, as I think about agriculture as a whole, as I think about my own state of Missouri, something we are blessed with is certainly diversity in agriculture. And we farm or ranch where we do because we have access to water. And as I think through this rule, every farmer or rancher has to think about the features that they have on their property and question whether all of a sudden now they are potentially jurisdictional and therefore fall under the authority of the EPA and the Corps. You know, as we talk about features, truly what comes back to my mind, Congressman, is uncertainty, regulatory uncertainty as to the responsibility that comes along with those features. You know, as I hear from our farmers, as they have questions because of the length and the scope of this rule, when they read terms like similarly situated, in the region, material influence, when they say, what do I need to do? You know, I can't in good faith ask them to go to one of our 6 district Corps offices in the state without first consulting with legal counsel or an environmental expert to walk them through the potential ramifications and what happens as they look at continuing to invest in their property and ultimately put more conservation on the ground. So that's what comes to mind, whether it's a low-lying area, a ditch, or anything. Our farms and ranches across the country are a mesh of all of these features. And truly, they are blessings when we think about access to water and ultimately our ability to produce food, fiber, and renewable fuel. Ultimately, this is what it's about for us, Congressman. It's about continuing to use the resources with which we have been blessed and are truly the envy of the world. So let's take a common sense approach to this, and that's what our farmers have asked for a long time. We want clean water because we need clean water for our families and for our livestock, but we also need clear rules. Thank you.
So, thank you for that answer. Several years ago, I think we had a joint hearing with Transportation and I think and the Senate and others after the Supreme Court had ruled the definition to be unconstitutional. At that time, the Army Corps of Engineers and the EPA, I believe, had joined up to do a new rule, which was similar or maybe even more oppressive than the one that was there. Now I'm hearing that they're teaming up again. Why do you think that is?
Is that directed to me again, Congressman?
Yeah.
Well, I would just say, you know, as I think back to the 2015 rule, I guess one thing that was certain is that there was the broadest expansion of the Clean Water Act, arguably, that we had seen since its inception in 1972. What's different about this approach? I would describe it as regulatory creep. Regulatory creep in the sense that it's going to come in a case-by-case determination across the landscape, whether that's in Missouri, California, you name it. So I still think the end result will be the same in terms of more dry land under the jurisdiction of the federal agencies, but it's going to happen over time, case-by-case, and ultimately a regulatory creep that's going to happen across the United States landscape.
Thank you very much. That's a great definition, regulatory creep. So thank you for bringing that up too. Mr. Chairman, I yield back.
The gentleman yields back. I now recognize Mr. Larson.
Thank you, Mr. Chair. Some questions for the panelists. I'm not a lawyer, I presume, from Mr. Williams to Ms. Huey to Mr. Hawkins, you're not lawyers as well, so we can maybe talk at that level. But I do want your opinion on the law. First for Mr. Hawkins, and maybe you don't have one, maybe the Farm Bureau has an opinion on whether or not you expect the Supreme Court to write a new test in the Sackett case if the government loses and the proponents win. What's your expectation?
Okay. Well, I would certainly hope that we
I'm asking what you hope.
I think that the arguments that the American Farm Bureau, that the Sackett family have put forward are very compelling arguments. I would say that.
Yeah, I'm sorry. Do you expect, though, the Supreme Court will write a new test? They could decide for Sackett and not write a test. They could write a new test. If they don't write a test, we have uncertainty. If they do write a test, you don't know what it is, and I don't know what it is, and that sounds like uncertainty.
It is uncertainty. That's why we've said no SCOTUS before WOTUS.
That
Or
sounds-
no WOTUS
that-
before SCOTUS. Sorry, I got it backwards.
I understood what you meant. Ms. Hugh, sort of the same question does it, for the home builders, what the position on that is. What do you expect if the proponents win, what do you expect?
Well, I'd still love to hope. But
We're in the hope business up here, but we have to actually make decisions sometimes based on what we know, what we don't know.
Yes, sir. I agree with my colleague. If we could have, it's the uncertainty that is the problem for us. I deal with codes and everything in construction that gives me a clear guideline for how to build a house.
Yeah, sure.
But this does not. We need the certainty and the clear rules.
And I don't mean to interrupt you, talk over you, but if you don't get a test out of the Supreme Court, if the proponents win, then you don't have a test, and we're left with uncertainty.
Uncertainty, yes,
That's kind of the point I'm getting at. I mean, the argument about certainty really doesn't fly. Mr. Williams, we talked yesterday, so it kind of teed you up a little bit on this. Do you have does the sand and gravel folks have a view on that?
We believe the Supreme Court will be able to offer a clear definition of what is jurisdictional, help us to create that line that says what is relatively permanent, what is not under federal jurisdiction but should be under state jurisdiction.
As clear as Scalia and Kennedy did in 2000 and whatever it was?
We believe they can come up with a clear definition this time around.
Thanks. I'm making my point. You guys get it. I'm making my point on this one. Mr. Owen, is it a fair assessment? I'm thinking through about this issue, how the kind of leave it to the states to fill the gap when the Trump era rule came out to fill a gap on clean water. Doesn't sound like that happened. Is it a fair assessment that there's little evidence the states had uniformly to come in to fill the gaps created by the Trump era rule?
So there have been some moves in a few states to fill gaps, but no across-the-board movement, nothing close to it. And it's understandable. Like it's essentially an unfunded mandate for states to come up with water quality programs to backfill what the federal government had been doing, or at least an unfunded request because they don't have to do it. And the states don't have the resources. They've been relying in many cases on a partnership with the federal government to protect waters and not developing their own programs. And so it's not an easy thing for them to do, and we shouldn't be surprised that they don't do it.
Yeah. Look, as a former county council member, I'm not, I support Clean Water Act, support clean water, support having the EPA involved, but I also understand that there's a frustration with uncertainty, and I'm just saying, thinking back when I was on the county council, trying to make some decisions as a local elected about what's certain and what's not certain on land use. I mean, I get where you're going through. I'm not arguing that houses aren't great and food isn't great and we don't need sand and gravel. I'm not making those arguments at all. I'm just concerned that we're not going to get what anyone wants out of the Supreme Court, because I just don't know. Unless they become an activist Supreme Court, which I presume we don't want out of the Supreme Court. I thought they weren't supposed to be activists, and they move forward and write a test. And so I just think we're headed towards a more uncertain future. And with that, I have no time to yield back.
Mr. Babbitt.
Sir, thank you very much, Mr. Chairman, and I want to thank all the witnesses for being here today as well. Unfortunately, over the last few decades, we've watched the Obama and Biden administrations use WOTUS and its definition basically as a political football, used to punish farmers, the energy industry, builders and contractors who rely on water and prop up lawyers racking up legal fees. Bigger government, confusion, and red tape, that's what this administration seems to see as an end goal to WOTUS. The rule was released as the U.S. Supreme Court prepares, as we speak, to decide a case, as we've heard today, Sackett versus EPA, which will provide more clarity on the issue. I'm very disappointed that EPA has moved ahead with its final rule while the Supreme Court will soon render a decision on this matter. And we can hope and we can expect and on, but the fact of the matter is the Supreme Court will make a ruling. And this ruling could negate major elements of this WOTUS rule and will create even more uncertainty for farmers. Unfortunately, the new WOTUS rule once again gives the federal government sweeping authority over private lands. And this isn't what clean water regulations were intended to do originally. This new rule is vague, it creates uncertainty for America's farmers, and even if they're miles from the nearest navigable waters. As a result of all this, you've seen members of the agriculture community rally and legally challenge this rule. Republicans strongly support this. Mr. Hawkins of the Missouri Farm Bureau, sir, this is your question. You've made some great points with your comments and some of your answers today. If there's one takeaway that you would like to the members of the committee and the folks watching at home to take away from this hearing today, please, what would it be?
Well, Congressman, thank you for the question. If I can talk personally, as a farmer and a father, there's nothing more that I want to do than bring my kids home to the farm. And as I plan for the future, everything that I'm doing is about trying to hopefully instill a work ethic and a passion for my kids that they love production agriculture and want to become the 6th generation. You know, right now we're investing our own dollars in putting in an intensive grazing system. This is the first time my family's actually contracted with the USDA to do something like this, to put more conservation on the ground. We already do conservation, but in this case, we put our own dollars on the line to cost share through the Environmental Quality Incentives Program. You know, as I think about this, we're doing it because it's the right thing to do, to better steward the forage that we have and to better steward our water resources, ultimately produce healthy cattle as we think about how we rotate those animals. And it's all about stewardship. As I think about this rule, though, I have to question, how is that going to impact going forward my ability to do more conservation on the ground or to construct facilities on the ground and how I manage my livestock? And then it begs the question, why? Why would my kids want to do it if they see their father embroiled in red tape with the government? And so truly, Congressman, as I think about this, you know, I implore you to help us help those who are going to come behind us, because that's truly why I'm here. It's about helping the next generation of those who are going to produce food, fiber, and fuel for this country.
Absolutely, and I really appreciate that honest answer. There's still a minute left. Any of the other witnesses would like to chime in on that?
I'd be glad to,
Yes, sir.
Thank
Mr.
you.
Williams.
Congress has provided an immense amount of funding for infrastructure. The aggregates industries wants to be the provider and get those projects done, get those projects on the ground. And if we have delays that come from wetland permitting and other delays that are required by this entire process, all of that just makes these projects last longer, and perhaps we can't even get our permits to open a new facility. So our dream is to get to work and be able to get our permits when we need them.
Absolutely. Mr. Chairman, I'm almost out of time, so I'll yield back. Thank you.
And the gentleman yield back the gentleman, Mr. Gramundi, is recognized.
Thank you. Mr. Hawkins, I wasn't going to ask you a question, but in your response to Mr. Babbitt, you very well articulated my own personal situation. I am a rancher. Our ranch is in a conservation easement. My question to you, as you talked about the future and about your ranch and your love of it, how would you write the law or the regulations to protect the waters that are on your ranch and adjacent and probably flowing into larger streams? How would you write it?
Well, thank you for the question, and thank you for your ranching background and what you've contributed through the years as well. You know, I would say what our farmers and ranchers appreciated about the navigable water protection rule was that for the first time since '72 that there were actual bright lines. And we in Missouri are very comfortable with the regulatory authority within our Department of Natural Resources and the example of cooperative federalism that we see under the Clean Water Act. We have a citizen-led commission, the Clean Water Commission in the state, that is essentially a sounding board and an oversight mechanism as the Clean Water Act and the state accompanying laws and regulations are implemented. So I would say, you know, in our example, we have a process that works. And so the bright lines under the NWPR were what were appreciated because for the first time we actually felt certainty. I would also add, Congressman, that, you know, outside of the scope of the Clean Water Act, you know, we in Missouri have shown time and time again that we're willing to go above and beyond to put practices on the ground that ultimately preserve soil and improve water quality. And since the mid-1980s, we've had in place a sales tax, the 1/10 cent sales tax, half of which goes to state parks, the other to soil and water conservation. That's been reapproved overwhelmingly by Missourians every decade since because it is proven to improve parks, but more importantly, it's helping us save soil and improve water quality by helping cost share with farmers to do more on the ground. That's what this is about, truly, for us. We've shown that we care about clean water and we put our money out there every day to access these resources to do more.
I appreciate that, but we're in the business of writing law. We've gone, what do we call it? Let's say we write, we rescind, and we repeat. That's what we've done for the last almost 40 years now. And it seems to me that we're going to have some clarity here in the law. Otherwise, we're going to continue to write, rescind, and repeat. And what my question to you, and really to all of the witnesses and to ourselves, is what should the law say? How do we provide clarity so that we don't go through this unending process, apparently unending process? I don't know the answer, but it seems to me that we have the responsibility of answering that question. That is, to provide the clarity in the law itself to the extent that, well, far more extensive than the present situation. Otherwise, it's going to be back and forth forever as the shifting winds of Congress and the presidency happen, and it will. I searched for that, and I really challenged myself. How would I write it? What would I actually put in the law so that there would be clarity? I understand the clarity and the necessity for it. I've got ponds that I know eventually drain into a river, and I'm going, how does this affect me? Don't know the answer, but we've got to search for that answer. And Mr. Graves, your resolution would prevent any further action until we wrote the law. I yield back.
Mr. Burlington.
Thank you, Mr. Chairman. Mr. Owen, I wanted to ask you, I heard previously you had mentioned that that states really can't shoulder the burden of some of this responsibility, that only the federal government has the resources to do that. I was puzzled by that because that's not, from my experience, the case. From our state's perspective, the EPA is really leaning on the state to do all of the work and shoulder all of the burden in enforcing their regulations.
Let me clarify the answer. What I'm saying is it's very hard for states to do it alone. In the same way that, as you just mentioned, it's really hard for the federal government to do it alone. And the system set up by the Clean Water Act is designed to be a partnership within areas where there is federal jurisdiction under the statute, but that there's also state authority. And I think the other point I would make is that that partnership has generally worked really well, where you have federal authority delegated to states, states acting with federal support and all working on a joint project of trying to advance water quality. And so the fear I was expressing is that when the federal government pulls back, the partnership goes away. And now the states still have the authority to act, but that would mean, in some cases, enacting new legislation, staffing up the effort, gaining experience, and so that's challenging. That's where the difficulty lies.
So certainly you can understand that the water issues in the Midwest are different than the issues in your state of California. Do you feel that the federal government creating a one-size-fits-all solution is appropriate, or do you believe that the states should have more control?
So I think calling it a one-size-fits-all solution is not quite right because there is some flexibility in the regulatory language that allows it to be adapted to the different circumstances of different places. That flexibility also leaves more room for interpretation, which is I think the fear that we're hearing from the rest of the panel.
Certainly, you've heard from some of the testimony from the farming community of the impact that they have. Do you sympathize or understand or share any of those concerns? Have you ever been on a farm or worked on a farm, tried to produce food to feed anyone?
So I have tried to produce food. I've gardened. I'm bad at it. So it was not a very successful effort, but I have made the attempt, and I have spent time on farms. I have not been employed on one ever, but I've... so to your question, do I sympathize? Absolutely. Absolutely. I think everybody on this panel would agree that water quality is important. I think everyone on this panel would agree that economic development is important, and everybody would agree that producing food, that producing housing, that all of these things really matter.
Thank you. Thank you, Mr. Ong. Mr. Hawkins, I appreciate you being here today. I wanted to get an idea. Whenever I was campaigning, I heard everywhere the impact of the supply chain on farming, the impact of energy costs, fertilizer costs, the impact of fuel costs. And I think my question to you, is this the appropriate time to saddle the farming community with these regulations?
Well, Congressman, thank you. Thank you for the question. I'd say there's never a good time to saddle agriculture or any sector of the economy with uncertain regulatory requirements. You know, Congressman, as we think through this issue, as we think through, the regulatory process alone, if a farmer is subject to a permit and must go through it, that's one thing. There's cost associated with that permit, of hiring the experts that are needed to help get you through the process. There are costs associated with mitigation, and there's costs associated with the time that it takes to ultimately see your project through fruition on the farm as a result of the permit. I'd also say you have the uncertainty that's associated with compliance and the threat of potential civil or criminal penalties.
I understand the cost could be anywhere from $10,900 to $2.4 million.
That's a lot of money, Congressman.
Right. The impact of a Missouri farming family, what are the average size of the family farms or the farming operations in Missouri?
Yeah, so the average size farm in Missouri would be about 300 acres. But again, Missouri, we kind of represent the diversity of American agriculture. We do everything but really citrus and sugar.
Yeah.
But we truly are a melting pot when it comes to just diversity of production.
So I imagine, that would be a huge impact to any family farmers. Thank you. My time has expired.
Thank you, Mr. Wilson. Ms. Sykes, I'll recognize you for 5 minutes.
Thank you, Mr. Chair. Thank you to the panel for your presentations today. I want to bring our conversation back to water quality, because essentially that is what we are talking about, and I'm going to direct this first question to you, Mr. Owens. We just talked a bit about an issue in my district where people who can't access well water, I know that's not necessarily their jurisdiction today, but the impact that it has on not accessing clean, potable water and what that means to your life and to a community's quality of life. So could you talk to us a little bit or provide some suggestions on how we can best add to clean water protections, somewhat to my colleague's conversation of what specifically could we do? What are the specific suggestions you have for us as we contemplate this rule in future legislation?
I think the first suggestion is that in order to protect clean water, we have to protect our rivers, our lakes, our streams, but also our smaller wetlands, our smaller streams, even the ephemeral ones. We cannot get the clean water that we want without protecting that natural infrastructure. That's a starting point. That's a foundation. It's not a complete answer to the question. Within that protection, there are a number of things we can do. The reality is that a lot of the water pollution that we have in this country comes from agriculture. In terms of the density of pollution from a particular area, it's higher in urban areas, but we have so much agricultural production, that's so much of our land, that's where a lot of water quality impacts come from. And so we have to find ways, whether it's through the kind of incentive programs that were described before, through regulation of non-point source runoff, through increased state effort, but that's a huge, I mean, particularly for your state of Ohio, where that is a primary source of pollution in Lake Erie, that is a huge focus. I'd say the other area where we need to do a tremendous amount of work is with urban stormwater. Because again, that's a major source of pollution. It's also a potential water supply, especially in arid areas. And it's a challenging, difficult issue because it is expensive for cities to deal with. So those are general answers. I'd be happy to follow up with more specifics, but I think that's a starting point.
Thank you, Mr. Owen. And I'm going to direct my next set of questions to Mr. Hawkins. And I know you're getting a lot of attention today, but it goes to show how important agriculture is. It is the #1 industry in Ohio, and we rely upon you, and we thank all of your members of the Farm Bureau across the country for what you do to feed us and allow us to live. But to the point of what Mr. Owen said, a lot of pollution is attributed to agriculture. And a couple years ago, we had some algal blooms in Lake Erie, which prohibited access to drinking water, again, impacting the quality of life of people who rely upon the beautiful Great Lakes for drinking water. So we're going to deal with the Farm Bill. I know that's not this committee, but everyone's still talking about the Farm Bill, and I'm sure we're going to hear conversations around agriculture, runoff, what you all are or are not doing to help us keep our clean water clean. So I'm asking you, what do you believe that, or what is your understanding of the normal farming activities exemption to the Clean Water Act, and do you agree that these activities are generally exempt from Clean Water Act permitting regardless of their jurisdiction of this rule?
Okay, thank you, Congresswoman, and again, thank you. I appreciate Ohio Farm Bureau a great deal. They have been mentors to me through the years in my Farm Bureau career, and so just a couple of thoughts initially. One, non-point sources are excluded, obviously, from the Clean Water Act, and as I think specifically to the issue that you raised in Ohio, I think it's a prime example of cooperative federalism at work, when the agriculture community worked with the state legislature and regulators to come up with a solution and put tools in the toolbox for Ohio farmers that worked. It didn't necessitate a heavy hand out of Washington, D.C. to solve a problem. It was Ohioans coming together for an Ohio-focused solution. And that's what I've learned from my colleagues as we have internal conversations within Farm Bureau, learning from other states about what works as we put tools in the toolbox for farmers. And I would just implore this committee, I appreciate you recognizing that y'all are going to be involved in writing a farm bill this year. And there'll be a lot of discussion about the conservation title. And I would implore you all to focus on working lands and make sure that farmers and ranchers have the tools that they need. Because guess what? If you make the programs workable, if you cut red tape, my fellow farmers and ranchers will raise their hand and walk through the door of their USDA office and say they want to put more conservation on the ground. So I would encourage you, keep that in mind. Make these programs workable for those who are working hard to produce food, fiber, and fuel.
The gentlelady's time has expired. Mr. Collins.
Thank you, Mr. Chairman. Ms. Bodine, my Baptist upbringing, I just got to add an amen to that opening statement. Thank you. You know, there are multiple new terms used in the Biden rule, such as regional, shallow surface, significant effects, and shallow aquifer management that appear throughout this remarkably long preamble, and it's in a variety of contexts. Now, what do these new terms do, and do they simplify or clarify or expedite the WOTUS process, or do they add more confusion to it?
Thank you for that question. The terms, as you point out, are vague. Most of the explanation is in the preamble, and everything is case by case. So it depends on the individual Corps field staff person, the individual EPA inspector. That is the person who gets to decide what the rule means. And the landowner is at their mercy to a great extent because of the fact that if there's a project that wants to go forward, people want clarity, they want certainty, and at some times they need to actually put themselves under the jurisdiction of the Corps just to get a jurisdictional determination in a timely way. So it gives enormous authority to the field staff on a case-by-case basis.
Thank you. Ms. Huey, I'm also a small businessman. You know, my wife and I, 30 years ago, we started our own business and grew it. And so I know firsthand how conducting business in an environment where regulations change every 2 to 4 years make it hard to stay in business. Matter of fact, I've seen a lot of small businesses that go out of business due to rules and regs imposed on them. Either that or they have to sell out to someone else to continue for their employees to have a job. And like you, Mr. Hawkins, I love what I do. And I've often said out there on the past several years that my kids don't have the same opportunity that I had, and that's to start and grow a business. And the reason is, in most cases, it's because there's some overreach by the federal government, by some bureaucrat out there making regulations, and who in most cases doesn't have a clue what they're regulating. So, Ms. Huey, I'd like for you, if you could, speak on how the final rule and the uncertainty that it contains and just how it's impacting your members, please.
It makes it very difficult when I have a homeowner call me or a potential client call me and want me to walk a piece of property with them that they've bought to build their dream home, and I see water standing on the property that I and my colleagues don't know what to do with. We have to walk back and say, I don't know what I can do with this. We're going to have to wait. We're going to have to go through the testing, through the process, and see if you can even build on this lot. That's for my colleagues all across the country. You know, we deal with regulations every day. Every day is a new challenge in our business, and you have to like challenges. We're not saying that we don't need regulation in our industry. We're just saying that we need to work together to come up with exactly what works for all Americans, for all properties.
Thank you. Thank you, Mr. Chairman. That's all I have, and I yield back.
Mr. Huffman is recognized for 5 minutes.
Thank you, Mr. Chairman. There's been a lot of talk about the need for certainty and reducing litigation. It would be easy to forget, listening to some of this debate, that before the Obama administration waded into this difficult, fraught exercise of defining the waters of the United States, there was incredible uncertainty. There was incredible conflict and litigation. That's why the Supreme Court waded in and confused us a little more with their different standards and tests. So I think it's important that we remember that it wasn't democratic rulemakings that created this problem of litigation and uncertainty. It was to some degree the lack of clarity and the lack of rulemakings, and to some extent the inherent challenge of defining something as tricky as waters of the United States if we're trying to protect water quality throughout the United States. It would also be easy to forget, listening to some of this debate, that the Clean Water Act is about protecting clean water, and that clean water is really, really important. It's been, in some cases, made into a bit of a boogeyman. It's been trivialized. It's been ridiculed, almost demonized by some terms of this debate. But remember how we got here. We had rivers that would catch fire, and we couldn't put them out. And it wasn't because, in many cases, the pollution that had been dumped right into that river, some of that came from tributaries upstream. We had Lake Erie and other water bodies that were written off as dead, as unable to support fish life because of all the pollution. Again, not because of stuff discharged directly into Lake Erie, but things that were discharged further upstream into tributaries and other water bodies that connect. So clean water matters, and this Clean Water Act is important. People throughout this country deserve clean water, and they value clean water. And I think they're frankly, if they're paying attention, pretty alarmed when you see proposals that would roll back protection for 70% of the rivers, 50% of the wetlands that have had that protection for the last 50 years. That's extreme. That's troubling. And so that's an important part of our context here. Mr. Owen, I appreciate your discussion of the importance of protecting headwater streams and unconnected wetlands, intermittent ephemeral water bodies, all of which would dramatically lose protection under the Trump administration's dirty water rule. And you discussed also how this contributes to toxic, costly algal blooms and other problems in downstream waters. I appreciate the fact that you drew our attention to the Clean Water Act's opening section, which states that water quality regulation must provide for the protection of and propagation of fish, shellfish, and wildlife, as well as provide for recreation. This wasn't just about navigation, or navigable waters was the jurisdictional hook that got us into the important challenge of protecting water quality throughout the United States. So could you talk a little bit more about why it is important that the Clean Water Act exists to support popular human activities like hunting and bird watching, fish and wildlife values, and why that should matter to all of us?
I think I would mostly say amen to the question. I think these things are obviously tremendously important. Water is, we all drink it, we all recreate with it. The public overwhelmingly wants stronger water quality protection. And in fact, to bring this back to what we've been discussing before, I'd highlight one other thing, which is that when we talk about constructing things in places that are wetlands or are ephemeral streams, we are talking about construction in places that flood. Like, we're talking about building homes in places that flood. And in addition to the water quality impacts of it, it's also a dangerous thing to do and a costly thing to do, because the federal government may ultimately be on the hook for the flood insurance payments. And so I think it's important to keep that piece of the context here as well, that the Clean Water Act is not only protecting our water quality, it's also protecting us from making costly mistakes of building in places that are prone to flooding.
What about the protection of groundwater? In California, everybody knows we're very concerned about the availability of water. In some years, 40% of our water supply can come from groundwater. Entire communities have lost groundwater due to pollution. And that didn't come from, it did come from groundwater plumes, but eventually that pollution traces back to surface water pollution. Why is it important that everyone care about groundwater when we talk about this issue?
Because a lot, I see the time's almost up, because a lot of groundwater starts as surface water. So what happens at the surface gets into the ground and gets into our drinking water.
Thank you. I yield back.
Mr. Van Orden, you're recognized. Thank you, Mr. Chairman. It was brought up during our testimony today that unfortunately some of the pollution that's in water comes from agriculture. I would like to remind everyone here that all food also comes from agriculture. I'm not going to mince words. This bill would be more aptly named WOTUS, as it's mostly confusing, partially nonsensical, not based in science, and will cause many more negative unintended consequences than I believe the Biden administration has contemplated. Under this new WOTUS rule, about 85% of the waterways in my congressional district will be subject to EPA oversight. In some places in my district, it would actually harm the environment, and I'm going to tell you exactly why. Several of my farmers are pioneers in environmental stewardship. What they started to do is they were collecting the runoff from agriculture in these ponds that they dug. And so what happens is the phosphates and nitrates settle to the bottom, then they're able to recycle the water, and they can also recycle some of these nitrates and phosphates, which lowers their input costs, which are killing everybody. So they partially recycle that. Again, it lowers the cost for everybody across the board. So if WOTUS goes into effect, these farmers will stop these practices as their ponds will become navigable waterways and subject to draconian federal regulations. And what this means is that all of these ag byproducts will actually enter the watersheds and wind up in the Mississippi River. That is the exact opposite intended consequence of this foolish regulation. We're concerned with the disappearance of small family farms who are just getting by due to skyrocketing costs, yet you appear to be advocating, this rule appears to be advocating for adding additional costs to their operations. So, Mr. Owens, you said that you have been to farms before. I've got boots in my office that have manure on them from a small family farm. And my first question to you is, when's the last time you stepped in manure on a small family farm?
This isn't the last time, but even though I grew up in the suburbs, we were the one house in the Boston suburb that got regular deliveries of horse manure from my mother's garden.
All right.
So I grew up not only stepping in that manure, but offending the entire neighborhood.
Great. And
with
how
the
old are
smell
you
of
now,
it.
Mr. Owen?
What's that?
How old are you now?
I'm 48 now.
How old were you then?
That was when I was a kid. More
Okay,
recently.
so 30 to 40 years ago is the answer to that question.
No, it's not. It's more recent than that.
Mr. Owen?
But next question.
So here's your next question. How many family farmers, township chairmen, and county board supervisors did you personally speak to about the economic effect that this is going to have on their villages, their townships, and their farms? How many did you personally speak to before you prepared yourself to come here to testify about the awesome economic and environmental effect of this foolish rule?
In preparing this testimony, I did not speak
Zero.
out to anyone.
Okay, that's my concern, Mr. Owen, is that we have a bunch of nameless bureaucrats who are trying to apply a 4,000-mile screwdriver to fix a problem that they can't even see. So when we have people that are deciding the fates of our family farmers without firsthand knowledge, they're actually degrading the ability of them to produce food for the world. And that is shameful. And we gotta stop it. So I'm gonna encourage you and the rest of your folks to get out there and talk to these farmers. Go to the township meetings. Ask them how it's gonna affect them. It's gonna destroy family farming. And I'm not willing to stand by and let that happen. With that, I yield back.
The gentleman yields.
Respond to that, or is,
The gentleman has yielded back.
okay.
Ms. Brownlee is recognized.
Thank you, Mr. Chairman. Mr. Owen, would you like to respond to the last comment?
I would tell you first off that I have spent in multiple research projects lots of time talking to farmers about the impacts of regulatory programs. I did not talk to them in preparing this specific testimony. The other thing that I would say is that I've also spent many years interviewing the agency staff who interview this and other programs. They generally are in field offices, so they are closer to the areas. They typically are people who grew up in those specific areas. And for them, what they have told me is having a sense of understanding of the community, being able to get out and see farms, or since that's not usually who they're regulating, see development sites, is really important to them as well. And so I think it's important to give the bureaucrats some credit here for the efforts that they have made to try to understand the people that they are regulating.
Mr. Owen, my question to you is, you mentioned that the requirement to obtain a clean water permit does not necessarily prohibit development, and that the property owners have use of compensatory mitigation. Could you elaborate on this option?
Yes, so if an area is declared to be jurisdictional, that does not mean it is off limits for development. The Army Corps will typically ask the landowner, can you avoid development in this area? And if they can, then they will prefer that. And if they can minimize impacts, they are again asked to do that. But if neither of those things are possible and the project still wants to go forward, you can get a permit, and coupled with that permit is a requirement to purchase compensatory mitigation, which basically means restoring environmental conditions in some other time or place. If it's done well, it can be a win-win, because you can get development where you want, and you can also get protection in places where it's desired. And in fact, a number of counties in California have done proactive planning to try to streamline approval processes and make this possible. They're good examples of how that can be done well. One other thing I would say to that point is, in the written testimony, there are some concerns about the cost of compensatory mitigation. Part of the reason for that cost is because the compensatory mitigation industry has had so much uncertainty because of uncertainty about whether regulatory restrictions would apply. If that industry has more stability, it will likely have more investment, and in the long term, that should bring costs down.
Very good. So in reference to certainty, and we've talked, and uncertainty, as we've talked a lot about in this hearing so far, and Mr. Garamendi sort of alluded to this in his line of questioning, but if the Congressional Review Act proposed by the chairman passes that disapproves the Waters of the United States rule, what would be the practical effect? And do you think it would repeal and create regulatory certainty or more uncertainty?
The short-term effect would be probably more uncertainty, although I think we're even uncertain about the uncertainty at this point. And the reason for that is that right now, the regulatory regime that is in place, because the implementation of the Trump rule was enjoined, is very similar to what this particular rule would create. So in the short term, it would not really change much of anything at all. In the long term, the Congressional Review Act prohibits a rule being adopted that is substantially the same, which is a phrase that courts really have not interpreted very much. We don't have much of a sense of what that means. And so that means the long-term consequences for future rulemaking and for responses to future court decisions would be really hard to predict. So I don't think that is a path to certainty.
Thank you. And I just have a little bit of time left, but you also noted in your testimony that the Trump administration's 2020 failed to use proper economic analysis. Can you elaborate on that a bit?
Yes, so to properly analyze the value of Clean Water Act protections, you need to look not just at the impacts upon regulated industries, and those exist, they are real, but also at the benefits that people get both through avoided costs of treating water, through avoided need to provide new water supplies, through avoided flood impacts, but also through things like hunting, fishing. You need to quantify those benefits as well and weigh them against the costs. And the Trump administration's approach was essentially to do an arm wave at the benefits and say either we can't calculate them or we don't think they exist. And the upshot of that was that you had a very, very imbalanced analysis.
Thank you so much, and Mr. Chairman, I yield back.
Thank the gentlelady. Mr. LaMalfa?
Thank you, Mr. Chairman. I'd tell you one thing. If Congress was writing this legislation now the way there's folks trying to interpret, Army Corps of Engineers, EPA, there's no chance it would pass Congress, certainly back in the 70s, nor now, because people would be calling for the heads of the members of Congress voting for such a far-reaching, overreaching piece of legislation. So here we are. Something was passed in the 70s that has been interpreted and reinterpreted more recently in the Obama era under WOTUS. Went very far-reaching to mean that human-built drainage ditches and agricultural irrigation ditches are now under the scope. We see areas that want to regulate water running off your roof into a rain barrel, saying you can't keep that rain barrel water without some kind of permit because it belongs to someone else. It seems the scope has expanded so much that no drop of water anywhere doesn't belong to the United States. So let's talk about home building for just a little bit. And also I want to touch too that Army Corps is holding up a project in my district for 3 years because it's about a half a mile from a river. So hearing Mr. Owen mention that one of the test questions is, can you avoid building this project? Can you avoid it? Well, no, I own this piece of land right here, private property. I want to build my building here, not have somebody ask me if I can avoid building it. I need it to store my equipment in or build whatever it is. So I want to come to, let's see, sorry here. Ms. Huey, you mentioned in your testimony there's basically 2 tests, I think as you put it, on when you go to build a house or housing project. One was stormwater runoff. What was the second one? Yeah, there was two pieces in line before you even get to water quality. So
I'm sorry, you're talking about the fill material.
Pardon?
Fill material.
Is that it? Okay. All right, so there was two pieces you would have to certify before you can get going on a project there on fill material, right?
I think it was that you were subject to 404 and then also stormwater controls.
Yes.
Okay, 404. All right, thank you for that. So you've already got a big lift in order to build any kind of housing project with those. And what are the timelines to get through those two types of permits to build housing?
In my area in Alabama, it takes several years to get through those processes.
Several years.
Yeah, and then there's even more layers after that. Once the development starts, we have, in Alabama, it's the Alabama Department of Environmental Management that we have to go through, and then the municipalities that come through every month and make lists of things that we need to correct, from silt fence to if we've got a pile of dirt that we've moved, that it needs to be seed and hayed, and if it's not, if we don't get it taken care of in a couple of days or a week or so, and that's when we have 3 detention ponds on a piece of property as well. Those detention ponds for a subdivision I was in about 4 or 5 years ago let the water out in an 18-inch pipe. And now a development that I'm somewhat involved in, we have to hold the water on the property for 24 hours, stormwater, before it's released.
And so what's the process of having to build the retaining ponds? Do you have to get permits for that? Because I know farmers and ranchers do, and sometimes they can't obtain those because you're somehow changing the watershed. How is that for you?
Right, we used to could fill out the forms to do that. Now we have to hire an environmental consultant, and that could be $5,000 to $10,000. The detention pond itself has cost about $100,000 on the project that I'm working on now.
To make a retention pond in order to do what they want to do so no silt gets away.
Yes, sir.
Because this is primarily about silt. When we're talking about pollutants, you seem to have plenty of regulations on how to use ag chemicals, farm chemicals, other things that are in a factory setting that are, someone's regulating all that effluent, what's coming off there. So when I hear talk of that 50% of it is agriculture, what we're really talking about is silt. And so if you go to any river upstream of agriculture after a heavy amount of rain, you see an awful lot of brown water coming down the rivers. It isn't fault of a farmer somewhere. And also you see that up in my district in Northern California, if they're successful with their extremism of tearing out some hydroelectric dams we need for electricity, we're going to release at least 20 million cubic yards of silt down the river. Now, silt is bad for gold mining and all that sort of thing, bad for fish, for turbidity, except we had a high-ranking official at a recent hearing say, well, the river is very starved for silt. So I'm wondering what the hell anybody's supposed to do, how any farmer, how any homeowner is supposed to figure out how to navigate this when it takes so long to get a permit to build a pond or anything else. 3 years. 3 years for this farmer in my district to want to build a building that he can't avoid building. I yield back, Mr. Chairman.
Gentleman's time has expired. Mr. Stanton, you're recognized.
Thank you very much, Mr. Chairman. Water is a precious resource. It must be protected, and no place does water matter more than in my home state of Arizona. 3.2 million people in Arizona receive their drinking water from systems that rely, at least in part, on intermittent, ephemeral, or headwater streams. As we grapple with the impacts of climate change and the worst drought in 1,200 years, safeguarding these waters is top of mind for many Arizonans. Across the country, water bodies vary from state and region to region, and so how waters of the United States is defined to account for these differences is very, very important. In Arizona, more than 90% of our stream miles are ephemeral, meaning they only flow during heavy rains. While these streams flow for only a brief period of time, they play a very key role in the arid Southwest, protecting water quality, recharging our groundwater, and carrying floodwaters and sediment flows to protect property. Mr. Owen, how does the rule account for regional differences in areas like in the arid Southwest that have a high concentrations of ephemeral streams?
I would say the most important way it accounts for them is by extending protection to not all of those ephemeral streams, but the streams that have significant connections to water quality in larger waterways. And that is, in a landscape like Arizona's, that's going to be many of those waterways.
How does the treatment of ephemeral streams under this rule compare to those issued during the Obama and Trump administrations?
Well, let me step back a little bit further. I think you often hear that we've been having dueling rulemakings and huge shifts. I disagree with that perspective to some degree. I think that the Trump administration rule was, in fact, a massive shift. Other than that, we've had a lot of continuity in terms of the scope of jurisdiction, really dating back not just to 1986, but to 1975. And so the Biden administration rule is, I think, not that different from what was done under the Obama administration before or after 2015, but it is also very similar to what was done under the W. Bush administration, the Reagan administration, the first Bush administration, and the Carter administration, and towards the end of the Ford administration. So there's a lot of continuity there. And the Trump rule for a couple of years was the outlier.
Thank you. I have a question for Mr. Williams. As you heard from previous testimony by Mr. Owen, these ephemeral streams were not protected under the previous rule advanced by the Trump administration, and there are challenges in some states to adding their own protections. So where do you think we can find common ground on this issue to ensure your industry has clarity and certainty for the work you do, yet broader protections for these important streams?
We're certainly in favor of broader clarity. We've been searching for that. I've been working in the wetlands industry for 23 years now, and I've been out in the field with some of our project managers, and they, I've had great experience in that, and I have a hard time deciding what is ephemeral and what is relatively permanent water. We've been looking for kind of a bright line in the sand of what that could be. Our industry is in favor of clean water. We need the aggregates products to clean water. Sand is part of biofiltration and water treatment. The ephemeral channels are a pollution issue, whether nutrients get into that channel or not. And this WOTUS rule is more of a construction issue. It's, where are we allowed to excavate or fill ephemeral channels, and that is more construction than it is any pollutant issue that we're concerned of.
Same question for Mr. Owen. Common ground, ensuring the industry has clarity and certainty, yet provide for broader protections for streams as I've described in Arizona.
So I think the honest answer is this is going to be hard. And it's going to be hard because no matter what standard we adopt, and this was true of the Trump rule as well as the more recent rule, drawing lines between water and land can be tricky where you have seasonal features. And it's really particularly hard in a place like Arizona where those features can go from dry for very long periods of time to torrential amounts of water moving through. And so I think, we all agree that certainty would be really desirable. I think in this particular setting, the only ways to get the level of certainty that industry is hoping for, and reasonably hoping for, but the only ways to get that would be to say essentially everything is jurisdictional or nothing is. In between, you're going to have hard line drawing problems, and I think the best way to approach those is to say, well, what are we trying to accomplish here? We're trying to protect water quality and honor the text of the statute. And if that does not produce perfect certainty or even high levels of certainty, that may just be something we have to live with, unfortunately.
Thank you. I'll submit my other questions in writing. I'll yield back.
Gentleman yields back. Mr. Duarte. Hello and thank you. I'm a farmer. We talk a lot about case-by-case analysis of Clean Water Act delineations, determinations. This is one time I'm very thankful to be the presenter right before lunch, because we all should look at my case very acutely and reflect upon our food system here in America. I planted wheat in a wheat field in 2011 that had been planted to wheat many, many times before and had wheat base acreage by the FSA determined across the entire property, 450 acres. Across the property were several streams that we did not farm for practical reasons, as well as, well, just for practical reasons alone, you don't farm streams. You can't get crop out of them. But it also had vernal pools, the largest of which wasn't an acre, the smallest of which was 16 square feet. All of them were determined to have been jurisdictional wetlands under WOTUS. These had all been farmed through the Section 404 permit process. Compromise made was clearly stated that plowing shall never be a discharge and soil shall never be a pollutant. But nonetheless, my family and I were prosecuted
robustly by the Army Corps of Engineers and the Department of Justice. American Farm Bureau literally put up the Duarte defense account. I believe I recall meeting Mrs. Bodine somewhere in the process here in the Capitol. And it became very much a flashpoint for American farmers and Clean Water Act jurisdictions. At the end of the day, having tilled 4 to 7 inches deep, wetlands features as small as 16 square feet, no larger than an acre, that had been planted many times before, I had the Department of Justice threatening me and suggesting to a judge, a federal judge, that my family be fined $28 to $40 million in penalties and restoration and mitigation costs. The Obama rule, when it came out, Farm Bureau took a look at it and started analyzing it and mapping it nationwide. Some states were 95% jurisdictional wetlands of their total surface area under the Obama WOTUS. Now we're talking about case-by-case analysis by field agents. Well, Mr. Hawkins mentioned that he works with the FSA, the USDA, the NRCS, many local agencies that are fully staffed within his county to help guide and comply with environmental and farming regulations, as well as improve practices and enhance conservation on his farm and throughout his county, throughout Missouri for that matter. In my case, we mentioned, Mr. Owen, your vision of a Army Corps of Engineer local field agent, having grown up in the area and being familiar with what was going on. Well, my field agent grew up in Southern California. He had a 5-county territory that he was set to serve. He thought I was tilling the ground 30 inches deep by his own deposition. That turned out to be, in fact, 4 to 7 inches deep. When I asked him to come to the field and take a look, he didn't have time and didn't respond. When they sent me a cease and desist order the following February, we requested a hearing and were kicked up to enforcement. We then went to the Pacific Legal Foundation, who saw the cease and desist order as a fairly dire offense to our Fifth Amendment due process rights, since we simply wanted to harvest our wheat and couldn't get direction as to whether that would be permitted or not under the cease and desist order, and were supported in the federal court until a retaliatory case was filed against us for destruction of wetlands. So I recite that, and I just want to make sure that we are on record that this is anything but a small nuisance or a small threat to American farmers. Mr. Hawkins, I'll yield back to you for what little balance of time I have left and invite you to give comments. If you don't, then Ms. Bodine may.
Well, Congressman, thank you for your story, your leadership through the years, your example that unfortunately is an illustration of what we've seen across the country, including the example I shared earlier. You know, right now we have a group of farmers who are working and have been working for almost 20 years in Missouri to save soil from being sloughed off along their creeks. They truly just want to save soil and improve water quality. We're undergoing a pilot project now, and the regulatory officials say it may be 2025 before they can reach a decision on how to proceed with said pilot project. Meanwhile, we're losing soil, and farmers just want to use rock to secure those banks and use a common sense, affordable solution that they believe should be workable. That's just another example. And I guess to your point, Congressman, I would just say what you've described illustrates and begs the question for those who are going to follow us of whether they want to come home to the farm or what you've experienced may be the deciding factor for mom or dad or grandma and grandpa to decide to exit the business altogether.
Thank you.
The gentleman's time has expired. The gentleman, Mr. Carter, is recognized.
Thank you very much. Mr. Owen, in Louisiana, one of the biggest challenges we face is in our coastal restoration. Our state has the highest rate of wetland loss in the country, with the state accounting for nearly 80% of the nation's total coastal wetland loss. To that end, officials across the state are working with stakeholders and federal agencies to consider diversion projects that may help restore our coasts. The problem is that the seafood industry says that these projects will hurt the fish and wildlife and the base of the Mississippi Delta. What steps might you recommend to be considered when weighing the needs of our coast and our bustling fishing industry?
So I don't want to get too deep into the weeds because the answers to any question like this are going to be specific to a particular landscape. But based on what I know of Louisiana, I would suggest a couple of things. First, I would suggest that Louisiana is an excellent case study in the importance of the subject we're talking about today. And that is both because of the amount of pollution that comes down the Mississippi River to Louisiana from other states, much of which could be contained more effectively with better protection of source water. So returning to our theme today, I think Louisiana has suffered more than probably any other state from the Clean Water Act not going as far as it needs to, not protecting as much. The second piece is on your specific question of how to balance the needs of the shrimping industry and the fishing industry with a desire to restore wetlands. Again, to the extent that you can limit other strains on those wetlands, which could include things like oil and gas activities that are affecting those wetlands, causing dredge and fill. Again, Section 404 of the Clean Water Act provides a protective mechanism. That doesn't get at the heart of your question, which is how do you balance restoration with the needs of the fishing communities? And the most specific answer, I think, is that I think you try to find common ground, reduce strains that affect both, and then try to do what you can to balance.
So you mean you don't have a magic wand for me?
I do not have a magic wand for you, no.
I didn't think you would. Do you see the WOTUS rules as helping facilitate to trend our state action and protect our water bodies?
Yes, absolutely. Because protecting wetlands from fill is very important, especially to a place like Louisiana where the wetlands are so important to the ecology. And then again, also because this gives you protection that you cannot provide on your own from pollution issues coming at you from upstream states.
Critically important. Mr. Hawkins, as the existential threat of climate change grows, one of the results is increased risk of flooding. Baton Rouge, in my district, suffered one of the worst floods in history in 2016. The community was devastated and needed help in rebuilding. Unfortunately, instead of bringing peace, the National Flood Insurance Program has only served to keep too many of my constituents up at night worrying. As a member of the Farm Bureau, would you please explain how the NFIP has hurt your industry?
Well, thank you for the question, Congressman. And honestly, to do it justice, I'll supply a response in writing, if you will, so that maybe we can get into those issues. But I would just say, historically, Missouri farmers, ranchers, landowners, certainly we sympathize and empathize with our fellow farmers, ranchers, and the residents of Louisiana. We experience flooding along the Missouri and Mississippi rivers, it seems like every few years. And so certainly floods present not just challenges at the time, but ongoing challenges from a recovery standpoint, particularly for us in agriculture when we repair levees and try to restore farmland to its pre-flood conditions. So the detailed response we'll get back to you with you and your staff.
Thank you very much. And Mr. Owen, could you likewise give a detailed response to the question that I referred to as well?
Yes, but likewise, I would also prefer to do so in writing rather than
That's what I
something
was referring to.
spontaneously
Would you
written.
likewise do it in writing? I yield back. Thank you.
The gentleman yields back. Now recognize Mr. Owens for 5 minutes.
Thank you, Mr. Chair. I'd like to yield my time to Mr. Duarte.
Thank you. Thank you, Congressman. How we doing? So another topic. The Army Corps of Engineers in my district, Merced County, is included, just had a river levee break and flood out a grammar school, an elementary school, in a town of many farm workers and lower income residents for the second time in 5 years. Mr. Hawkins, is the Army Corps of Engineers, in your opinion, competent in their primary responsibilities of flood control, levee maintenance, and are they prepared and staffed to take on the additional responsibilities of regulating every farm in America down to its last mud puddle, or in your case, riprap installation along a drainage?
Well, Congressman, thank you. Thank you for the question. I would say, within Missouri, we have had a long-standing let's say, open conversation with the Army Corps of Engineers. From the local issue I raised about just the movement of gravel to secure and slow soil erosion, to how the Missouri River is managed. Unfortunately, with what we have seen in Missouri, and Chairman Graves knows this all too well, we have seen the Endangered Species Act essentially used as the trump card to help dictate to the Army Corps of Engineers its management decisions for systems like the Missouri River. So that's long been the frustration for our farmers and landowners, is that they feel like the ESA is used as the trump card and the species are put above people.
Thank you very much. We had the exact same situation. We had rivers and ditches that needed to be drained. The irrigation districts locally were very willing to put the resources into providing the backhoe, the excavator, and draining them. The Army Corps couldn't issue a permit because Fish and Wildlife wouldn't permit the permit. It went back and forth for years. Meanwhile, these families are flooded. They're throwing their couches, their belongings, their clothing into dumpsters parked along the street. They're being hauled away to the city dump. FEMA is out there making very meager offerings of support to help these families reestablish and balance their books and get on with their lives. They'll be stripping their drywall, their carpets, and rebuilding significant amounts of their houses simply because Fish and Wildlife and the Army Corps of Engineers couldn't get it together to perform their core responsibilities and functions. So thank you. There's more similar than different. Ms. Bodine, I know you've been at these types of issues for quite a while. We're sitting here on the precipice of not only a Supreme Court WOTUS decision coming down that should give us clarity on what is, the significant nexus that has been, in my opinion, manipulated by the agencies, but also Chevron deference cases coming down this year. And I'd like you to walk us through what we can expect and how some clarity may come in this year's Supreme Court sessions.
Thank you, Congressman. So I actually reread the oral argument from the second case, I think yesterday. But the based on the well, first the issue presented to the court.
If you can lean just a little bit more in the microphone.
The issue presented to the court was whether or not there was a significant nexus to a stream that was actually north of the Sackett's property, in fact, across the road from the Sackett's property.
It was an adjacency issue, but yes.
But it was adjacent not to the lake, but to a stream, which was actually a ditch that flowed to a stream. But in that case, the justices were troubled, and this includes Justice Sotomayor and Justice Kagan, by the significant nexus test. The Deputy Solicitor General presented an argument that the significant nexus test was really about hydrology, which is very disingenuous because as I spoke earlier and in my written testimony, it's much, much broader than that. It includes these biological connections. So I actually would suggest and perhaps anticipate that the justices will not uphold a significant nexus test. The question then is what else, and I think that was questions other people have raised, and that I don't know, but I thought that they were deeply troubled by the significant nexus test in that case.
So in this window of time, when we have a new rule put before us that may not be supported by the Supreme Court, the most efficient thing right now would be to exercise our responsibilities under the Congressional Review Act, set this aside, and wait for clarity to come down from the Supreme Court. I also would like to ask, and maybe in a future session I will, can we make a deal anymore? In 1972, we sat down with the agencies and the other side of the aisle, and we've created the Clean Water Act. And we have serious limitations on what those authorities were that have been greatly eroded by the agencies. Will we be able to solve the next problem?
Gentleman's time has expired. Mr. Williams is recognized.
Thank you, Mr. Chairman. I'm just going to rapid fire a few questions and comments, and if you could keep your answers brief, it will make sense, I hope. Mr. Hawkins, my wife and I also started a farm, or are members of the New York Farm Bureau, and we live in a beautiful place that has Skinny Atlas Lake, one of the cleanest lakes in the world. In fact, it is provides the drinking water for the city of Syracuse untreated, and it's one of the few in our country to do so. It's surrounded by farms, and it's surrounded by homes, and the Farm Bureau in our state has been critical to working with farmers to to implement those things to keep that water pure. And it's a great success story. I know those farmers, have toured their farms. I've seen the investment that they've labored under. I just want to move on, though, to Mr. Williams, no relation. You're familiar with the T-clip test? And in a very brief way, can you describe how you use T-clip in your minds?
A T-clip is a toxic characteristic, so soils and other potentially hazardous materials are analyzed to see if they have things like mercury or arsenic, or if they have cyanide, or if they're going to affect groundwater in a long-term situation.
Right, and passing T-clip is one of the key features of being able to release water back into the environment, or if it has to undergo further treatment. I spent a lot of time around acid mine drainage, in the mining industry, looking at novel new technologies to treat that water. And so that's why I know about T-clip. But thank you for that explanation, because it's really important. And Ms. Bodine, you are an expert regulator and have spent a career in regulating issues. Based on the testimony today, and of course of your own study and understanding, are you concerned that the proposed wording of this rule would open the way for very selective prosecution, for great discretion to be applied by EPA administrators on who and when and what to prosecute? Because, as many of you, in fact, all of you have testified, there's a great deal of uncertainty and vagueness in the language of the law. Are you concerned that this rule could open up that kind of prosecution?
Yes, I am, because it is a case-by-case determination.
That's right.
I would point out that the GAO looked at this issue back in 2004 and found out that there were just vastly inconsistent interpretations of what was Clean Water Act jurisdiction by different core districts across the country. The examples that I put in my testimony, which included Congressman Duarte's experience, also showed how individual field agents can make decisions that would be considered very extreme, but it's difficult for the landowner to push that.
Thank you. Mr. Owen, one question for you. Have you ever read the Gulag Archipelago? Are you familiar with that work? Okay. I commend it to you. It's an excellent work. I'm just going to read a few quotes, and then I'll conclude my time here. Nothing is easier than stamping your foot and shouting, "That's mine." It's immeasurably harder to proclaim, "You may live as you please." I think that echoes really much of the testimony here. He goes on to say, unlimited power in the hands of limited people always leads to cruelty. And I think if you listen to the farmers and builders and even the mines, you'll hear that concern. The last quote I will share with you is that you only have power over people as long as you don't take everything away from them. But when you've robbed a man of everything, he's no longer in your power. He's free again. And I share that with you because I'll close with a quote often attributed to Joseph Stalin's head of secret police: "Show me the man, and I'll show you the crime." And I believe that's what this rule leads to in the hands of the EPA regulators. I yield back, sir.
Gentlemen's time has expired. Mr. Massey is recognized.
I thank Mr. Rouser for yielding me 5 minutes. Ms. Bodine, in Kentucky, when we build ponds on our farms, there's this miraculous thing that always happens. You can go 500 feet up on top of your hill and dig a pond, and within a few months, there'll be frogs in it. There'll be snapping turtles. And these snapping turtles ostensibly should be 500 feet lower, as we know frogs can climb it. And then within a year or two, even though you've not stocked the pond, you end up with fish in it. It's sort of a miracle of life, and it's one of the reasons I would say farmers are the greenest people on the planet, because we love building ponds. Can you describe, I was actually surprised, but it does feel like Groundhog Day. I think we were here 8 years ago or 10 years ago with the WOTUS ruling that expanded things, and now there's another attempt to expand. But can you talk about this effort to increase the jurisdiction of the federal government into isolated waters and how they're using the life that just generates in these ponds as a nexus?
Yes, thank you. And that is the significant nexus test. As I pointed out earlier, the Supreme Court in 2001 called into question whether there was jurisdiction over isolated waters, and since then, neither EPA or the Corps have tried to regulate them. This rule tries to reinvigorate that authority using a significant nexus test, which isn't just water pollution, water quality. It's not even just water. It's literally moving, biota, whether it's larvae or plants, from one location like your pond to another by an animal, and that's enough of a nexus to bring a pond into jurisdiction if it's not exempt. Now, there is an exemption for farm ponds built wholly in uplands, but it would be burden on you to show what was there before you built your pond, and again, having to meet that burden would be quite difficult.
Besides fish and frogs, we always get cattails, and we're not happy about that. But life just spreads, like you said, and I think it would be dangerous to put it on the burden of the landowner to say that he had a farming nexus to avoid this wildlife nexus that the federal government seems to be trying to create here. I appreciate you flagging that for us. Ms. Huey, particularly taken by your testimony because I'm in a growing district. There's a lot of need for housing, particularly affordable housing for people that work. For instance, in our Amazon facility, we have an Amazon hub in our district. And the home builders, there's literally nowhere they could put 20 houses together. Now, you might be able to go find a place where you can put 1 or 2 houses and not run afoul of some federal nexus, but there's almost nowhere left in northern Kentucky where you could put 20 houses without getting into this issue. Can you talk about, my home builders right now are facing inflation, supply chain issues, and higher interest rates. And that all goes on the homeowner, whether it's a first home for somebody who's just trying to get their family started, or whether it's lower or moderate income housing, multifamily dwellings. Can you talk about how these regulations add to the cost of that type of housing?
Certainly I can, and I think you named everything except workforce. We have workforce challenges.
We're working on that. We've
Yes.
got an internship program.
That's wonderful. So yes, we are dealing with all that, and it costs more money because it takes more time to build houses. All the regulations and the increases during COVID that we experienced with fuel surcharges and just the increase in materials.
How long can it add to a project?
For me, a custom home that I build that's about 3,500 square feet would take about 8 months. It's taken me almost 12 months now. For some first-time home buyers, a builder in my area that could build a house in 4 months, it's taken him 8 months. So the process takes longer, there's more interest we have to pay, people have to wait longer, so they're paying more rent in their apartments before they can move in if they're first-time home buyers, and it's just a domino effect all across the board.
One of the issues we run up against, because I'm in a tri-state area, is disparate decisions depending on which corps you're in, or division, or which state. Do you see that as a problem across the nation, is disparate application of these laws?
You're talking about with the Corps, is that what you said?
Yeah, the WOTUS ruling and how the regulations that trickle from that. Can she answer? Mr. Chairman, can she answer the question?
The gentleman's time has expired.
Wow, he's quick with the gavel, but I'll take a Republican chairman over a Democrat chairman.
I treat everybody fairly. Mr. Ezell.
Thank you very much, Mr. Chairman. We've heard today how constantly changing, overreaching regulations confuse hardworking farmers and landowners. It's also clear that a lack of certainty leads to higher costs and delays for essential infrastructure projects. Mr. Williams, the aggregates industry plays an important role in building our nation's infrastructure. What happens to mitigation cost when your business is forced to work with a new jurisdictional definition?
When the jurisdictional definition is expanded and we have to find other ways to mitigate for a project, that increased costs and time delays. It's a multifaceted answer. If mitigation credits are available nearby, we can purchase those credits, but frequently there are no longer mitigation credits in that area, so then we have to come up with other ways to mitigate for the project. We have one project in South Carolina where we had to build our own wetlands there because there were not mitigation projects available. Another cause could be that the cost just becomes astronomical. We had a particular project that we looked at under the 2020 rule that had about 1,800 feet of jurisdiction and maybe 2 acres of wetlands under that rule, but under an expanded rule, it became almost 8,000 feet of streams and about 8 acres of wetlands because of the ditches present on a former agricultural project. That made the mitigation cost rise from $780,000 for the first definition to $3.8 million for the second definition. So that's over 4 times more, or over $3 million more just for that one project.
Thank you. I'd also like to discuss a key issue before the Supreme Court, the legality of the significant nexus test. How does the significant nexus test expand federal jurisdiction over waters? What will happen if the Supreme Court limits the scope of significant nexus?
When we look at significant nexus, we have a couple different definitions already. When we were using that definition 10 years ago, and actually under the regime that we're in now because the vacated rule from Trump, the significant nexus said if it affected the physical, chemical, and biological integrity of the jurisdictional water. And they have now inserted the word or instead of the word and. And so we have to, if it affects any of those certain things, we've had a number of moments of testimony today about how ludicrous that might be for bird feathers or other things that have been discussed. So it has a significant effect on what could be jurisdictional and how that affects our projects.
Thank you. Mr. Huey, you mentioned the same significant nexus test in your testimony as well. How would the current rule affect real estate development? Ms. Huey, I apologize.
That's quite all right, thank you. It would dramatically affect home building in our industry. For the significant nexus test, you know, I used a simple example or I thought of a simple example yesterday. I've got a customer that wanted me to put a fence up for them. They got a new, got a puppy, wanted to put a fence up. They have the a ditch beside their house. Only gets water when it rains. Have we got to go through the significant nexus test just to put a fence up? That's what we're looking at with the test.
Thank you very much. Mr. Chairman, I yield back.
Gentleman yields back. Ms. Gonzalez-Colon.
Thank you, Mr. Chairman. I think all of us are aware, share an awareness of the importance of protecting our water resources and making sure that we can have the necessary economic activity to, without causing harm to waters that everybody depends on. I'm coming from an island, I can tell you about that. At the same time, many of us are aware of the challenges that we are facing when needing to engage in, for example, recovery of infrastructure and agricultural production after disasters. And that's my own experience. When compliance with regulations becomes confused due to the changes in guidance, and this is why it is important that the rules about protecting waters are stable and consistent, and of course, clearly focus on the congressional intent of the Clean Water Act. For my district in Puerto Rico, as an island beset by tropical storm, it is a constant struggle to make sure that the necessary work for prevention and mitigation of floods or shore erosion, or for even protection of public-private properties near bodies of water, and for protection of the drinking water supplies, once approved, can begin and be completed as planned promptly. And this will change all of that. And we have received large amounts of federal funding and for mitigation, but very often we find that the local entities who are a critical part of this effort, like the municipalities, state agencies, the nonprofit organizations, cannot start to do the work until permits and authorizations are processed, and for which requirements sometimes are unclear, or change from one administration to the other one while the work is halfway through. And that's our current situation. We got thousands of projects, federal funding projects, and this is the case of Puerto Rico, but the same thing happened in natural disasters all across the nation. How this new ruling is going to affect the cost of all those federal projects, the permitting process as well. So I think consistency and clarity of rules is critical to make sure they are implemented well and achieve the intent of the legislator. And in this case, the Waters of the United States rules, Congress delegated that power in the Army Corps of Engineers and EPA, the two agencies recognized for their high technical expertise, but even they have to face changes in direction that can make their own work even harder. So in that sense, I mean, when I'm hearing all the different stakeholders and how these affect them, and particularly in the agricultural sector and the home builder sector, this is a very important one for me since all of our states and territories find themselves needing more affordable housing. My question will be how this will affect directly all that federal reconstruction projects that get underway right now. I mean, building.
Yeah, thank you for the question, Congresswoman. I had the opportunity to visit Puerto Rico, beautiful Puerto Rico, twice this past year. So, and had meetings with the home builders there. There are extreme challenges with rebuilding. It just, and the having to do the significant nexus test and everything, it just delays the process and makes it a lot more expensive. There is no affordable housing right now, in my opinion, with all the regulations that are coming down. I want affordable housing for everyone. I want home ownership, the American dream for everyone, but the affordability is a crisis in America.
You visited the island, so you know how instability in this rulemaking will impede the development or redevelopment of safe, affordable housing. In our case, we don't have any more space to build. And when I saw Ms. Parker Bodin, you included in your presentation a map of locations of karst geology, and almost all Florida, large parts of Missouri, Texas are included there. And what that means for farm ponds and isolated wetlands that are in those areas, because we do have the same situation in Puerto Rico and we cannot move them. So what's going to be the effect of this ruling in those karst geology areas? Ms. Parker?
I'm sorry, what'll be the effect on?
On all areas
in the karst areas, yes, thank you.
Farm ponds.
So they have, the new rule identifies karst, which, karst geology would mean that there's, fractured bedrock and water flowing through it. That's a basis for creating jurisdiction, calling something adjacent. So it would vastly increase the waters that would be regulated.
Thank you. I yield back.
The gentlelady's time has expired. I will note that any question that you want to provide additional answers to or supplement your answer to, the record will be open, and you can do that at that time. I know 5 minutes is a short period with a complicated topic such as this, and so just want to make sure you're aware. Any question that was asked to you where you want to add to your answer, you certainly have that opportunity to do so in writing. Seeing no other member that has not already been recognized, this concludes our hearing for today. I'd like to thank each of the witnesses for your testimony, very good testimony, I might add. And I ask unanimous consent that the record of today's hearing remain open until such time as our witnesses have provided answers to any questions that may be submitted to them in writing. Without objection, so ordered. I also ask unanimous consent that the record remain open for 15 days for any additional comments and information submitted by members or witnesses to be included in the record of today's hearing. Without objection, so ordered. The subcommittee stands adjourned.